Someone make it make sense.
Probably a couple.
Hello, hello. How are y'all doing? Let me make sure my settings are normalized here. Okay, looks good. Excelente. Welcome, Meg. Welcome, official, whose notifications are working now. Oh. Do, re, mi, fa, sol, la, ti. Do. Just finished that one. AB. Twiz, are you practicing your alphabet? Welcome, Annie. Couple things. First of all, for you, Meg. So I was like, I haven't done any, I haven't updated my hair in for fucking ever. And so I haven't done any blonding in for as it were. And anyway, so I've got a solid probably foot or longer of regrowth, as they say. So today I was like, I wonder if my lightener even is still good, because I know that they can expire or whatever. So I was like, well, let me just test it out. So I haven't done it in so long. I took just a little section of my hair and I highlighted it. I got all the stuff, the foil and the comb and all the shit, and I highlighted it. And it looks so good. I can't even believe it. So now I have it looks really good. I should take a picture of it. It looks really good in this one spot. So now I need to do the rest of my head. So anyway, that's fun. So I have that project coming up at some point. And also, so for those of you guys who were here earlier for Lori, I don't know what all happened with the Alan Jackson arrest. I didn't hear back from Miss Mandy, and I can't find anything about it. So we'll keep our eyes peeled. I don't know if maybe, it seems like she has an inside source locally. So I just don't know. We'll keep our eyes peeled for that. And then, okay, another thing here. So speaking of Lori, I thought that Detective Moffat was going to be called to the stand. No one was arrested, Meg. Apparently there's an arrest warrant out for Alan Jackson. I haven't seen we don't have any more information yet. So who else thought Detective Moffat was going to be called to the stand in Arizona? Raise your scroll paw. Me. And remember, we had thought there were going to be more witnesses left for the state. And they ended with Nathan Duncan, and they were supposed to have 2 more. I don't know what the deal is with that, but it's funny because the whole time during trial, whenever Lori would be asking questions for different witnesses that were clearly questions for Detective Moffat, I was ask Detective Moffat, wrong witness, ask Detective Moffat. And there was just so much that it was that's a question for Detective Moffat. And for anyone who's wait, which one was he? The way that he was memorable, in my view, was he was memorable for, that's why Duncan got involved. Because remember, Detective Moffat is the one who apparently had the file and walked by and chucked the file on Duncan's desk and was your problem now, basically, right? So, welcome, Sudie. So, which is interesting. That's a whole vibe. The way Detective Duncan told that story was really interesting. I don't think I have that part timestamped yet. But anyway, it was really interesting. So I was where is Moffat? And then I'm also in the back of my mind thinking little Miss Moffat sat on her Toffet. What is it? A Toffet? What even is a Toffet? Anyway, so I did some research. Not a lot of, anyway, basically here's what I found. So weirdly, Detective Moffat testified in Idaho. Go figure, right? Because like he's a Chandler Police Department detective, and here we are in Arizona. He didn't testify, but he testified in Idaho. That's thing number one. Thing number two is that what's thing number two? Oh yeah, he recently got promoted like 7 months ago within Chandler Police Department. Because so part of me was like, well, maybe he's deceased. And the other thing is today during the jury instructions, it came up. Like I was they were talking about people. It was actually at the beginning when they were talking about the jury instructions, and one of the people that Judge Boreski named of like people who aren't available or like aren't testifying, but the jury heard a lot about. He mentioned Detective Moffat, Summer Shiflett, and I forget who else he named, maybe Alex Cox, but he definitely mentioned Detective Duncan and Summer Shiflett. And I was like, I mean, that's why I was like, is Detective Duncan deceased? And apparently not. Or sorry, not Detective Duncan, Detective Moffat is detective. That's who he mentioned. He mentioned Moffat and Summer Shiflett. And I was like, this is so intriguing because we've been talking a lot about Summer, but now this Detective Moffat is like a whole thing. Like, what is going on with Detective Moffat? So for our next Lori installment that we'll do, maybe tomorrow, we'll see. Just sort of depends. We're going to do MIA and AZ, and we're going to do Moffat. We're going to do Summer Shiflett, and we're going to do Milligan. So Twiz just left the gym. How was your workout, Twiz? Did you do good? Everybody congratulate Twiz. Yay! Twiz doesn't drink coffee, weirdly. Welcome, Dean. Happy to see you again. Thank you for that, Happy Annie. Yeah. Now the other thing is, like, I don't know how that would work too, because if he's back in California, I mean, I don't know that he would be, right? But like, I don't know how that would work jurisdiction wise. That's another interesting factor of that whole thing with Alan Jackson. Like, Sudi says, how can I do all these different cases and be sane? Whoever said I was sane? No, just kidding. I don't know. Like, are you asking in terms of like keeping all the information categorized in my brain, or like from the standpoint of like these people are all crazy, or feel free to elaborate. But probably no matter what the answer is, I don't know. I do love coffee. Thank you for that, Meg. A Tuffet. Okay. So not Moffat, it's Tuffet. Okay. Got it. Welcome, Leslie and Billy. What does this mean, Twiz? Almost 100 from the cold? What does that mean? Are you talking about weather? How's Billy doing, Leslie? Oh, deadlifting. Gotcha. Okay. That's funny, Twiz. 225. That's like 2.5 me's. Oh, also, we have a new clip here thing. I know you guys hear me say this all the time, but just in case, just to hammer the point home.
Just because somebody pleads the fifth, just because somebody doesn't talk to cops, just because somebody hires a lawyer, does not mean they're guilty.
So let's watch that just one more time for the win.
Just because somebody pleads the fifth, just because somebody doesn't talk to cops, just because somebody hires a lawyer, does not mean they're guilty.
So there you go. Twiz's beer could do 150. Yeah. So like, okay. So you're thinking about keeping, it sounds, Sudi, it sounds like to me, maybe you're talking about keeping all the facts straight. So as far as, so I guess sort of what helps me particularly. So I have different playlists for each one, and that helps it that like for what's funny for me, like visually, when I'm thinking of a case, right, that I'm covering, my brain like automatically pulls up. I don't even do this. It's not like on purpose. It just happens on its own. Like I see the thumbnail, and the thumbnails are all very different from each other. I don't know if this is anyway. For me, the visual difference helps me categorize things. So I think that when I'm getting new information on a case, I'm automatically I'm automatically filtering it into like that case's playlist, which I'm picturing the thumbnail basically, if that makes sense. I don't know if that makes sense, but that helps for that. Also, I have files on my computer for each case where I put things related to that case. And also in the Discord, we have threads for like each case. So, but honestly, for me, I think that, and I didn't even realize this until now that you've asked. I didn't even realize this, but I think that automatically, like for example, if I'm going to the Duval County clerk of court site to see if there's any new files for Shannon Gardner, my brain automatically is visualizing the thumbnail for Shannon Gardner. I mean, I didn't even realize it was doing this until now. And so then when I get new information, it goes and it associates with that case because of the thumbnail. Does that make any sense? Truth Seeker, I think you are new here. So I love the name though. Welcome. Yeah, I was just wondering, Happy Annie, if you would have to if the warrant, if Norfolk County is where you'd have to look for the warrant, or if you would have to look. I would imagine though that the warrant would show up wherever it is in California. I mean, because that's where they would have to extradite him from if he's there. Sounds good, Twiz. We'll hold you to it. Yeah. And so that's part of it too. Like, so for the thumbnails, right, they all have different fonts and different colors. And honestly, and it, like, yeah, like that visualization for me, I think is really helps categorize it. Yeah, it's different for a viewer. Yeah, that's a good point. Yeah. Yeah. Trying to think if there's a good tip I could give you guys. In a way, it's funny because in a way, it's easier when you are the one covering it, and versus following. Because if you're like, for example, like before I was covering cases, when I was like following cases, if you're following them on different channels, then it's at least the tip that I just gave wouldn't apply, right? You know what I mean? So yeah, I see what you're saying though. Yeah, I mean, for those of you guys who are following these cases, do you save information from them? Because if so, maybe there is a way you could do it where you like, color code things or even just a graphic, right? Welcome, Tonka. Okay, have I seen you in the chat before, Truth Seeker? If so, I apologize if I feel like your name is so memorable though. I feel like I would have remembered. Twiz. Twiz. Twiz, you thought that the other day about the Annie number 2. Shout out to Annie number 2. And you were wrong. Haha. Meg, don't quit YouTube. Welcome, P. Fox. Annie, are you okay? Are you okay? You okay, Annie? Thank you for that. Right. Yes. Thank you for that, Leslie. I was thinking I was trying to help out people. Like Needs and Z's made a good point, right? For people who aren't like that. I have my own system, but she made a good point, which is that it's different for people who aren't covering the cases for people that are following them. So I was trying to think of a tip to help those people out for you guys, right? It was a great question brought up from Sudi. So anyone else who's new, welcome. Let us know if you would like a custom command. Also, next members only. No, totally. I definitely did not interpret it as complaining at all. You guys know me. If you ask a question, I'm going to try to be very thorough in answering it. And I'm also a problem solver. I like just try to. Yeah, Meg, I miss you. I feel like I haven't seen you in a couple days. Yeah, Sudi, let me know what you want the response to be. So, and Nightbot will set it up for you. Yeah, Meg, you're just hanging out. Maybe you're hanging out in the wrong places because literally just yesterday, I think it was, I was like, where is Meg? I haven't seen her in a while. And I was wondering if you were okay. Are you okay, Meg? Yeah, so as far as our next members only live stream, we're going to do trivia night again. And welcome in with us, Nora. We are going to be doing trivia. Here's trivia for next one, guys. We're going to be doing famous quotes, firsts in history, movie trivia, musical theater trivia, trial trivia, and 90s music. So for those of you guys who are competitive, get ready. Mittens for Kittens. I don't think I know Mittens for Kittens, but sounds like love the name. Sounds like a cool person. So Sudi, your command would look like this. Just let me know what you want the response to be. And anyone else who's new also. Twiz tried to type amethyst. A for effort. Can you bet for real? Bet, you mean for the trivia game night? Like taking bets? You can bet scroll points. Oh man. Glad Twiz is being Twiz because that reminds me of something. Hold on, I have to unshare, reshare. Promised I would do this, and here we are doing things. Okay. Twiz's new map. What do you guys think? Earlier today, when we were doing Lori Vallow, Northwest was in the chat. Shout out to Northwest. Northwest follows the Lori Vallow Daybell cases, and that's like their thing. I think that they don't even follow really anything else. To my knowledge, that's their case, right? And so they're always there for that coverage. And anyway, it was funny because Twiz was asking questions about, whatever Twiz was asking about. And Northwest was trying to answer the questions. And I was like, Northwest, I was like, Northwest was like, go back and watch this footage from yesterday. And I was like, Northwest, I was like, Twiz was here yesterday watching it with us. He was in the chat. And I answered these questions yesterday. And then I said a couple other things. And then Northwest replied with, oh, Twiz is special. Okay, I got it. It was just, I was dying laughing. But this map is a great example of why we love Twiz. I just have to say, we've upgraded the crayon abilities, and look at this fancy arrow. No, they were not. They were totally not getting mad. No, that's like a situation like when you've got someone who knows all the facts of the case, right? Like inside and out, and like they want to be able to help people who don't because like, you know what I mean? Again, it's like if you're that person, like you've got your one, if you got like your pet case, right? As they might say, where it's like, you know, you want to be the helper in the chat. Like that's like what Northwest, that's my interpretation is like they're helping people out because like that's their case and that's all they, you know what I mean? So they're not. I thought that was hilarious though. I'm like, yep, he's special. All right. I've seen Sharknado. Awesome movie. Definitely. So what was let me follow back up with this. What was the deal with the betting? Oh, officials referencing 50 Cent there. Were this was the taking of bets, was that related to the trivia night or something else? Oh, well, that could explain it. That's funny, official. Speaking of which, pick your poison. So after we do this, because I don't think this is going to be too long or anything. That's what she said. But if we want to do something after this, the people get to vote. We have options, guys. We have options. We can either do movie night on Discord, and we have options there. Options include, but are not limited to, but well, I guess they do kind of, okay. They include, let's just put it that way. The Room, for anyone who missed it, which is official was there. He can speak to it. Greatest B movie of all time. One of my all-time favorite movies. It is amazing. It is hilarious. You guys will freaking love it. And it's anyone can go, and it's going to be in the Discord if we do that. That's option one. We'll do a vote at the end of this live stream. Option number 2, Runaway Jury. I've never seen it. Apparently it's, you can get it for free on YouTube. Like I just saw it on YouTube and it's like a free movie. So I was like, oh my God, it's called Runaway Jury. I don't know anything about it. I've heard of it. That's all I got. I don't know anything about it. I don't know if it's good, if it's bad. Either way, sounds like it's worth watching. And if nothing else, it'll be interesting to see how accurate they get things, right? Because usually in this type of stuff, there's a lot that's inaccurate. And it'll be really interesting to see. I feel like it would be worth watching. If any of you guys have seen it, let me know if you have thoughts. So that's option number 2. Option number 3 would be Lori Vallow, MIA and AZ, like I was talking about earlier with Moffat, Shiflett, and Melanie Gibb. And then option number 4 would be Alex Murdaugh cross-examination. So 2 Discord movie night options and 2 YouTube case options. So I see. Gotcha. Yeah, the bets would have to be imaginary, right? You know, y'all can make your, of course we can, y'all can bet to your heart's content, right? Y'all can, the sky's the limit, right? For sure. Of course. 100%. We can do bets. Yes. I have no idea what you're referencing, Leslie. BK Sisters movie? What? What is boring? I didn't know I could put games in the chat. I have no idea how to do that. Yes, Murdoch is cross of Alex. She's thinking Annie knows. Annie, I think I see where you're going to go with that one. Yeah, Alex cross. What is boring, Amethyst? I hope I'm not boring you. Okay, so oh, you're saying, are you saying Runaway Jury is boring? Is that what you were saying, Amethyst? By the way, Sudi, let me know what you want your command to be. Dean, if you want a command, also let me know. So here's the thing. We can't just suggest random movies. I have to already have the movie for us to be able to do it immediately after this. Like I have to have the movie to watch it in Discord. So I can't just like, I'm not a Blockbuster. You know what I mean? So I only suggested Runaway Jury because I just happened to see it on that it exists on YouTube. I have the room on my computer. So as far as movie options, those are the two we got for tonight anyway. And then we have also like, again, the two YouTube options. Meg says Lori gives her a headache. So we might be working with Alex on Cross, which honestly is so fucking good. It's so good. It's so good. Okay. So now we're going to, I know, right? Yeah. I thought that would make you guys laugh. So, okay. Now we're going to jump on into this though. All right. So let me unshare, reshare. It is so epic. I agree. It is literally the best trial of moments of time, all time. So, okay. So first things, sorry, my brain. First things first, I'm the realist. Drop this and let the whole world feel it. And I'm still in the murder business. I can hold you down like I'm giving lessons on physics. Don't you want to add bitch like this? Something. Anyway, okay. First things first, here's the new documents. Yeah, disappointing because like so much is under seal, right? So, anywho, the one thing I wanted to say is this. I wanted to follow back up on the affidavit and the SIRE and the hearing. So, you have movies you can loan me? Do you have it on VHS? What are we talking here? I mean, I can get movies for the most part. I mean, maybe with some exceptions, but most of them I can get. It's just I wouldn't have them ready, like immediately. So, okay. So following up on the hearing, so a lot of you guys had mentioned as far as the whole 7 days thing, and you know that part that was so like when SIRE was there and Judge Hippler wouldn't let him talk, and so a lot of you guys mentioned that there's this FBI like cast, I forget what it is at this point now, a cast report, something there, manual. No, it was a manual, right? Where it says something about the amount of time that needs to be kept. And I know that somebody had commented, I believe it was AZ on one of the videos, and said that was like not in use anymore because it was 3G, not 5. I don't remember specifically, but regardless, is the thing I wanted to say is this, because a lot of people were commenting on that manual thing. And what I wanted to say is this, because I thought about this after we covered that hearing, I thought about this logically. It's like as I'm like just thinking in my brain, and I was just thinking, and I was like, by the way, Meg, did you let me know how I can put games in the chat? How that works? And also I miss Heather. So when Twiz uses his box, Twiz, what are you talking about? Is your mind in the gutter? So yeah, so the thing. So I was thinking about this in my brain, and I was like, well, here's the thing. If, because a lot of people were saying like, oh my gosh, this is so stupid, with like a 2-second Google search, like you can see that like this is not the case, and there's this manual. All you do is like Google it, and here it is. And I was like, here's the thing. There's only 2 options here that I can see as far as that goes. Option number 1, that manual doesn't apply for some reason, right? That manual doesn't apply for some reason. Option number 2 is that Ann Taylor is going to be bordering, if not definitely on ineffective assistance of counsel. Like, for example, if this huge thing, right, make or break with this motion in limine and being able to refute the 7 days, and it was just as easy as a quick Google search, and she didn't bother to do that, and she didn't, something that anybody can find on the internet, and she didn't have that, and it was that easy. Are you kidding me? Like, I don't know that you could think of a more incapable attorney, right? Like that would be ineffective assistance of counsel. And I like between the two, which is most likely, Ann Taylor is like ineffective assistance of counsel. Like she's like just completely inept, like worse than Lolly, right? Is that, or is it that maybe for some reason that manual doesn't apply and that maybe Ann Taylor knows better than other people? And I would go with that option personally. So, Twiz verifying he's not a girl. Roger that. Oh, it's a Nightbot thing. Okay. Right. Yeah, I know there's commands for it, but I don't think it just puts the games in. Like I think you have to have other things. I text her. It's not a game. I don't, are you talking about me? So if you're talking, that's funny. Halo is coming up again. Yesterday, was that no, 2 days ago, I played, no, wait, was it yesterday? Anyway, I never had heard the Halo theme. I figured it out on violin during the lunch break for Lori. And I played the Halo theme because as per Twiz's request. I also love Ann Taylor. And I do think that if it was as simple as finding that thing, I think that she would have had that. And so, yeah. Not to get involved with his testimony. I don't know that I understand what you mean. I feel like Cy was chomping at the bit to address Hippler. I mean, Hippler said some words, right? And it was so rude of him to not let Cy respond. Speaking of which, so this was filed on 4/8. Stipulated motion to seal defendants exhibit 4N in support of their objection to the state's motion to eliminate timing advance records. So we don't know what this is because it's fucking sealed. But what we know is this. This was filed on 4/8. And what it is an exhibit in support of their objection to the state's motion to eliminate with the timing advance records. Any guesses? Anybody want to take guesses for fun as to what this is? We could even do squirrel bets for fun, imaginary. Sudi, did you come up with your command yet? I think official is wrapping, which is cool. Well, so they definitely didn't want him to testify at the hearing, but they're not keeping him from testifying at the trial. Actually, and the reason I say that, I think they did seem to be doing that. The reason I'm saying that now is because there were a couple moments that happened in the most recent hearing where they actually, for their argument for the state's argument to win on one other thing, I'm forgetting which thing it was. In order to win on one other argument that the state was making, they needed to concede that Cy Ray would be testifying. And so they made that concession. But I forget exactly what point that was. Maybe I'll think of it when I'm not trying to think of it. But that did happen. And I made a mental note of that, of like, oh, now whatever the thing was, it worked to the state's benefit. Like they needed to make that concession that like Cy Ray will testify. Might have been related to the alibi. I think that's what it was. I think it's when they were discussing the alibi. Yep, I think that's what it was. I think that's what it was actually. But yeah, they're definitely playing games. There's no question of that. Can I give you one? Well, you have to decide what you want, though. I mean, I can make you one, but I don't know what do you want it to say, Sudi? Whatever you want. I can make it whatever you want. Man, if they close that to the public, though, Tonka, no, bad. So Sudi, let us know what you want your command to be. Okay. So yeah, so there you go. That's all that says. But yeah. Okay. So next up we have this is so I don't know if you guys want to go through this. I don't know that it's worth it. It's interesting because this dude's not on the witness. Like he's not been talked about as a witness. I double checked actually after I went and looked at this. I was like, huh, this is just this random dude. So this is what's his face? What his name? What is it? Christian Westring. And so it's his affidavit. This is in support of this is for the inconclusive data. And it's like this 26-page affidavit. I mean, and as always, it's Exhibit S1 because literally everything is Exhibit S1 or S2. That's going to be a disaster during trial, guys. But basically, I mean, we can go through all of this. There's this qualification. Let's just take a look at what it is. So there's qualifications. And then this is like real DNA-y. Like this is into the DNA weeds of it all. Like, I don't know that this will help any of us. Like, you guys, can you see this? Like, I don't, like, you know, over my head, you know, I don't remember what a heterozygote is. That was from biology in like 6th grade or something. Anywho, I mean, this looks super advanced and crazy looking. That's all I got here. We can read it, but do we want to read it? It's really a question. But I wanted to show you guys so y'all could let me know. It's not an expert disclosure. It's just an affidavit in support of the inconclusive data. They've not said anything about this person being an expert witness. That's what's so weird about it. I don't know why. Maybe because it's too late. They just had this. This is just a different person who just did this one affidavit is what it looks like. It's very weird. I feel like AI would break official if I asked it to do that on this. Like this is, and I don't even know how to do that. Like that would be kind of funny though to see what it does. How would one go about asking AI to summarize this? Does someone know? So it's just this one affidavit. Now, I mean, it remains to be seen. Maybe they are going to try to enter him as an expert for something, but as of yet, that has not happened. So it's just funny. I still don't see what Sudi's command is going to be. She says, Twiz, that's me. Going in circles in Halo. Are we doing that? I'm going to make that. Okay. I can't type. I mean, maybe an emoji. Should we do an emoji here? Let's see here. All right, let's do this. I can update it and change it. Just let me know. But there you go. What do you think? Okay, so if you guys want me to have AI summarize this, I think that would be funny. You know, I love doing the AI adventures. Should we do a real quick AI adventure, guys? Should we do a real quick AI adventure? I think we should. Hold on. Let's do this. Let's do this right. I need to convert this to text. Hold on. I already have a thing, dude. Adobe, don't be annoying. So it's going to do the thing, and then we can do AI adventure. For any of you guys who've not been here for this, you're in for a treat. All right. Let's find a good word. I think locus. Where'd that go? Okay, I don't need to edit it per se. I just need it to recognize the text. Hang on. Okay. Oh, you know why? I usually don't do this in Chrome. I usually do this the other way. I get it. That's why it's different. Okay. I need to open it in Adobe PDF. Hang on. Oh, there's generate a summary. Convert to PDF. Oh my God. No. I don't want to add an image. Okay, well. We can't do AI journey unless okay. We'll come back to this. How about that? And we'll do the AI journey because I'm going to have to do this a different way. All right. Next up. The AI journeys are fun though. Welcome, Angel. Sudi, did you like your new did you like your command? Yeah, the DNA stuff is intriguing. I mean, are you able, Tonka, to understand the science of it all though? Like, does that make sense to you? Because if so, that's amazing. That's not necessarily my wheelhouse. Music, scrolling, and law, orchids, Russian, scrolling again. Also, Angel, if you'd like a custom command, same for you, Truth Seeker, y'all let me know. I said Russian. Yeah, like the language. Okay. So we have, this is interesting. Okay. So right. We have an order on family members in the courtroom. So here's what happened. Right. Here's what happened. I realized that Tonka does have a command, Meg. I realized that when we were watching the hearing, I realized that I had somehow the one motion eliminate filing I had somehow slipped through the cracks and I hadn't covered was this one that we're looking at here. And this was the state's reply to the defendant's response in objection to motion eliminate regarding the immediate family and members in the courtroom. So we're going to read this and then we're going to read the order. Okay. So because we hadn't done this one. Somehow we missed it. So probably because there were 50 bazillion documents. Yeah, that could be why. So this is from the, what is it? 321 batch. All right. The state is in agreement that immediate families should logically include step parents and relatives by marriage. The defendant stipulates to the individuals listed within State's Exhibit S1. Again, there's 50 bazillion S1s. It's going to be a nightmare trial. Mark my words, guys. Therefore, the state moves the court for an order allowing the family members listed, again, typo there, families members, listed on states Exhibit S1 to remain in the courtroom during the entirety of the trial against the defendant. Regarding courtroom decorum, the state defers to the court's inherent authority to supervise their officers, parties, witnesses, counsel, and jurors. Fine. Okay, defendant requests that members of his family be granted the same rights as the victims' families. However, the immediate families of homicide victims have constitutional and statutory rights to attend pursuant to Idaho Constitution Article 1. So let me read that again. So the defendant is requesting that his family members be granted the same rights. What they're saying is the Idaho Constitution has a statute for the family members of homicide victims. There's no comparable constitutional or statutory provisions affording a defendant's family these same rights. There should be. That's insane. Further, there is no authority to support the argument that the defendant's Sixth Amendment rights would be violated. The defendant has a constitutional and statutory right to a, quote, public trial. They put that in scare quotes for some fucking reason. But that does not extend to defendants choosing whom sits in the courtroom. And here's why I remember. Here's how I know. Sorry, Meg. Here's how I know we didn't cover this. Because I would have goated. I'm goating now. Just shaking my head. This is depressing. In addition, the state may call members of the Kohberger family to testify at trial. Prior to the start of trial, the state anticipates it will motion the court, or the court will on its own accord generally exclude testifying witnesses from the courtroom so they cannot hear other witnesses' testimony. So here's the first thing I'll say about this. They're really trying to exclude the family, and they don't have a good reason. Why do I say that? Because they're giving, it's one or the other. Like, don't just, why do I want to say pussyfoot? Literally, I've never said that in my life. Don't just fuck around with like, you know, we're going to call them as witnesses. Why is this damn bullshit happening in every fucking case? Dude, Lori Vallow happening. Karen Reed. Like, what is this nonsense? Why are we playing games with calling people as witnesses? I mean, I'm so tired of it. This is so dumb. It's so juvenile. It's such a waste of time. Why? Tell me why. There you go, official. Seriously, tell me why. So like, if you're saying, if your argument here is that there's no provision in the Constitution for it, like we wish they could be there, but unfortunately there's no case law for it, and there's no provision in the Constitution. Like, that's fucked. Like, the judge does have the discretion; he could set precedent. Meg, that's funny. So, you know, but they have to add in, but also, right? We might call them as witnesses, and there's an exclusionary rule. They can't hear other witnesses' testimony. Dude, I cannot. Footnote 1. The parties filed a stipulated agreement of the parties regarding investigators in the courtroom during trial. The court entered an order to this effect on March 4th. Great. Wonderful. Well done, Ashley. Then they follow it back up with, again, defendant's family are not exempted from Idaho Rule of Evidence 615. Therefore, those members of the defendant's family on the state's witness list should be excluded. So this is why in other words, it's just like, if you just don't want someone to be there in courtroom, you just list them as a witness, and then it's fine. That's what we're seeing in all these cases. I'm fucking sick of it. That's what we're talking about here. No. Okay. Hang on. There's different issues here. There's different issues happening here. So for any witness, doesn't matter who it is, okay? Whether it's the defendant's family or not, any witness, right? With the exception of Murdoch, okay? Exception to every rule there. There's an exclusionary rule where witnesses cannot be listening to the trial. That's it. Like, there's a handful of exceptions. There's a handful of exceptions. So, but generally speaking, right, there's that's standard par for the course. And that means they can't be present at the trial. It also means they can't be watching it. In a lot of trials, they will ask every witness when they go to take the stand after they swear them in. I mean, this is usually, like, I've seen many trials where this is just done in public. After they swear them in, they literally ask them in front of the jury and in front of everybody, the world, like, have you seen or heard anything? Have you been watching the trial? Have you seen anything in the news? Actually came up in Lori's Idaho trial with one of the witnesses there. Anyway, so it's the witness exclusionary rule. That applies to everybody. Okay, so why does that matter here? Because if the state lists the defendant's family as witnesses, which is what they're saying they're going to be doing, the state may call members of the Kohberger's family to testify at trial. Well, now what does that mean? It means that they would be excluded from being able to be present, right? And there would be an exclusionary rule for the victim's family, but not for the defendant's family. What that means is if, for example, the state's going to call immediate family members of any of the victims, per the Constitution of Idaho, they have a statute there that grants them exclusion. Here, look. Because they have constitutional and statutory rights to attend. So even if they're listed as witnesses, doesn't matter. They can still be there, or they can watch on TV. Either way, whatever they want to do, right? Does that make sense? So we're not at the point of talking about what happens if they test. That's not what this is about. This is about trying to keep them from being in the courtroom by listing them as witnesses. And that's also correct. Happy Annie's correct. This is something else they can do. And they did this in Lori's Idaho trial. They did this with Kay Woodcock. That's another option. They can call the witness at the very first start, like like what they did in Lori's Idaho trial with Kay Woodcock, because in that case, she wasn't considered immediate family members of the victims. The state called her first. So that way she was done testifying and then she could be present for the rest of the trial. So that's a good point there. Thank you for pointing that out. I'm just reading what you guys are saying in the chat. If they get called to the stand, they can't plead the fifth. Pleading the fifth only applies if you could incriminate yourself. I mean, and what I mean by that is if take Turtle Boy, for example, right? That whole thing, because he's got his criminal charges pending. We were talking about this when we were watching the Karen Reed hearing, and I'd forgotten at the time. I remembered it after that. I forgot at the time that he had his own criminal charges pending for the witness intimidation because I don't follow all that. But yeah, he's got criminal charge. I forgot that he has all that, right? So anyway, so pleading the fifth, you only have that right. It's against self-incrimination. So his family, BK's family, if they are actually called, they can only plead the fifth if they're going to incriminate themselves. I don't know how that would happen. I don't think they're being charged with anything. Yeah. So if they were to try to plead, like, it wouldn't work, right? They could be held in contempt of court if they didn't answer questions. You know what I mean? You're talking about spousal privilege doesn't apply here, Tonka. There's spousal privilege, right? That's it. That's the only privilege that would exist for that's non-Fifth Amendment related. Like spousal privilege is literally just for married people. For example, Shanna Gardner and Mario Fernandez Saldana, another case I'm covering, they're estranged, but they're still technically married. Same with Lori and Chad, right? They cannot be forced to testify. You cannot be forced to testify against a spouse. But other than that, parents, siblings, doesn't matter. It's all good. It's all fair game. You can subpoena them to testify, and they can't plead the fifth. Now, they could just be difficult witnesses, but then they could be, the state could ask the court to treat them as a hostile witness. I will just say this much. I don't think they plan on calling the family, guys. I think this is an attempt to keep them out of the courtroom. I think that's all it is. I don't think because here's the thing. If like all of the things I'm talking about are what could happen, right? But what the state could choose to do, because if the state's going to put any of these family members up there and the family members are just going to be difficult, right? They may just they just wouldn't call them. Like they have that option, right? Like in other words, it could look bad in front of the jury. There's myriad reasons, right? I think this is just an attempt to keep them out of the courtroom. I don't think they really intend to call them. Yep. Young Thug. But he had criminal charges pending, so lots of them, if I recall. Okay, so, but we have the judge's order. So let's find out what he says. All right. The state requests an order pursuant to these articles of the Idaho Constitution. By the way, Amethyst, was it you that was referencing something specific in the statute for burglaring? Let me know, so that I love breaking down elements of a statute. So we could pull that up. Okay, so all right, allowing immediate family members of the homicide victims to be present during the entire trial, regardless of whether they are scheduled to testify. Right. Attached to the state's motion as Exhibit S1. You guys, this is going to be a nightmare during trial if they don't get this shit together with their exhibits. Is a list of those individuals the state considers to be immediate families under the foregoing provisions. They are siblings, parent, grandparents, and step-parents of the deceased, footnote 3. Oh, wait, hold on. Did we miss these other footnotes? Let's read these other footnotes. Okay, so footnote 1. This provision allows a crime victim to be present at all criminal justice proceedings. Footnote 2. Collectively, these statutes allow the immediate family of homicide victims to be present at all criminal justice proceedings. Footnote 3. The state points out that immediate families is not defined by Idaho code. However, based on its statutory definition in other contexts, as well as the definition provided by Black's Law Dictionary, the state contends it includes all those individuals listed on Exhibit S1. Defendant agrees with the state's analysis. Welcome, AZ. Why did they need to charge him with burglary first? Oh, God. Yeah, so there was... Hold on. Let me pull up the statute. I remember we talked about this. It mattered. It mattered for one of the aggravators for the death penalty. That's why. It wasn't a charging. It was a charging decision, probably because they already knew they were going to be seeking the death penalty. This matters. That's where this mattered, because one of the aggravating factors was one of the things. Yeah. In order to seek the death penalty, it was like in commission of a crime, right? Like, in other words, did you murder people in commission of another? That's what it is. Did you murder people in the commission of another crime? The other crime is the burglary. So that's how they were able to seek the death penalty, because the murders happened during the commission of another crime, the other crime being burglary. Burglary defined: every person who enters any house, room, apartment, tenement, store, shop, warehouse, mill, barn, stable, outhouse, or building, tent, vessel, tent. I've gone camping in a long time. Vessel, vehicle, trailer, airplane, or railroad car, with intent to commit any theft It's interesting because this is very specific. I worry that there's going to be some things that don't fit in these categories because they were so specific. Anyway, let's read these again. So, because this is crazy. House, room, apartment, tenement, store, shop, warehouse, mill, barn, stable, outhouse, building, tent, vessel, vehicle, trailer, airplane, or railroad car. There's got to be other things that should count that aren't listed. Anyway, with intent to commit any theft or any felony, so murder being one of them, is guilty of burglary. Right. Entering with intent to commit a felony. Yep. Yep. Go to that next. How? Tell me how. Let me see. Maybe this is how. Is this how? Okay. All right. Let's see here. So I don't think we need commercial burglary. Punishment for burglary? That's not what we need. Burglary with explosives? Poison of burglarious? What is that? Are you talking about jury instructions for burglary, Amethyst? I want to know about this, though. Possession of burglarious instruments. Every person having upon him or in his possession a picklock, crow. Sorry. Key, bit, or other instrument or tool with intent feloniously to break or enter into any building, or who shall knowingly make or alter, or shall attempt to make or alter any key or other instrument above named, like a crow? I'll answer that question in a second, official. So the same will fit or open the lock of a building without being requested. So to do by some person having the right to open. Basically, if you've picked a lock, that's what it is. That makes sense. Yes, California does have the death penalty. However, it has been in what is the word? It's on. There's a governor. What is the word I'm looking for? Governors. The governor has mandated it. Oh my God. It's basically on hold. Like it still exists, but there's been a pause. It's not been abolished or anything like that. So it still exists, but there's like a pause on it. What is the actual? Hold on. It's gonna drive me crazy just in my own brain if I don't have the actual word. Can't think of it right now. Moratorium. That's the word. Moratorium. That's what it is. Since 2006. So there's like a bunch of people that are basically like on death row, but aren't on death row. Like in other words, no executions are being carried out since 2006. Sorry, no. The moratorium started in 2019, but they've not had any executions since 2006. So people can still be like sentenced to death, from what I understand. I've delved way into this on different live streams where we've talked about the death penalty, but I know there's like a fuck ton of people on death row, but there's not being executed. So sanatorium, yeah. Moratorium. So now you were saying look at the jury instructions. Okay. Oh, did it download it as a Word document? That's odd. Hang on. All right. Hang on, guys. Okay, in order for the defendant to be guilty of burglary, the state must prove each of the following. 1, on or about date, so what, November 13th, in the state of Idaho, the defendant name entered, place entered, and number 4, at the time entry was made, the defendant had the specific intent to commit either theft or name of the other felony. So let's go through these elements again. So they have to be able to prove the date, the state, the name of the defendant, and the place that was entered. And while we know that identity is at issue, we know that the name that will be here will be Bryan Kohberger and the place will be 1122 King Road. And at the time entry was made, the defendant had the specific intent to commit, and it will be not theft, it will be the other felony, which is murder. That's the entire page. What am I missing here, Amethyst? Esmeralda, welcome to, sorry, welcome to Official's Sister. And I started laughing because that comment was underneath it, AZ. Welcome, Esmeralda. I love the name Esmeralda. This is the only page. Did I need to go back to the search? Hold on. Maybe we need this. We'll see. All right. Conspiracy. I feel like we've gone through all these in different live streams. Technically, you probably fall under this one. There's arson, trespassing. A burgle. We're looking for a burgle. Cannibalism, yikes. Jesus Christ. Where is burglary? Property. Oh my God, it's downloading the same thing again. I swear to God. It's just downloading the same thing again. Help! Did you now, Official? How would that go for you? Right. Okay. I mean, are you talking about the one here? Like, I don't think that's the right place. I just don't know where to find it. I've clicked on all the things. So, anywho, I haven't seen Royal Tenenbaums in forever, I will say. I mean, oh God, it's just downloading that again. All right, we'll table that for now. Let's go back to this one. Okay, I've just downloaded the same document like 50 bazillion times. Excellent. All right, so the state points out immediate families is not defined by Idaho code. However, based on its statutory definition in other contexts, as well as the definition provided by Black's Law Dictionary, the state contends it includes all those individuals listed on Exhibit S1. Defendant agrees with the state's analysis. Okay, so that was footnote 3. Defendant stipulates that the individuals listed in Exhibit S1 may remain in the courtroom during trial, but asks that the court provide guidance as to the proper courtroom decorum to discourage family members from wearing clothing or apparel that could be viewed as coercive by the jury. The state agrees that the court has the discretion to issue rules regarding courtroom decorum. At the appropriate time, the court will exercise its discretion in this regard. Footnote 4. Nonetheless, the parties can rest assured that those attending trial will not be permitted to display in any form or media messages or signs of support or opposition related to the parties or issues in this case. Further, no demonstrations or outbursts of any kind will be permitted or tolerated. I have no idea where Twiz went. Good question, though. Twiz! Cuckoo! Cuckoo! Calling all squirrels. However, in its response to the state's motion, defendant requests that his immediate family members, siblings, and parents be allowed in the courtroom, arguing their exclusion would violate his Sixth Amendment right to a fair trial. The state objects on grounds that while family members of homicide victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family member. So what's happening here is the court is summarizing the arguments that have been made in the pleadings, as well as at the hearing. So basically, where'd it go? The state objects to the defendant's family on the grounds that they're not, the rights only by statute apply to family members of homicide victims. And then the defendant is saying it would infringe on Sixth Amendment right. The state also contends that it intends to call members of the defendant's family as witnesses at trial and will ask the court to exclude any testifying witnesses from the courtroom pursuant to the Idaho Rules of Evidence. The United States Supreme Court has recognized that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant, at the very least, to have his friends, relatives, and counsel present, no matter what offense he may be charged. Okay. Courts recognize that having a defendant's family members present at trial advances the values served by the right to public trial, ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. However, like other constitutional rights, a defendant's right to public trial is not absolute. The right to an open trial may give way in certain cases to other rights or interests. A partial closure of a trial, one that excludes a limited number of persons for either the entire or part of the trial, is permitted if there's an overriding interest for the closure and the closure is narrowly tailored to serve that interest. Here, the purpose for the closure requested by the state is Idaho Rules of Evidence 615, which provides, in relevant part, that at a party's request, the court may order witnesses excluded so they cannot hear the other witness's testimony. This is a discretionary decision. Oh, there's a footnote. The 4 exceptions to this rule do not apply. Okay. So the rule says, again, in part, a party's request, the court may order their witnesses excluded so they cannot hear the other witness's testimony. And then the 4 exceptions to that don't apply, it says. While court is sensitive to the state's concerns about allowing witnesses present during trial, the court is also sensitive to the fact that it is anticipated to be a lengthy trial and that the defendant would like the support of his family. Footnote 6. Angel, I'm sure it's just your imagination. It is just your imagination running away with you. It is just your imagination. Promise. Amethyst, where is the paragraph? Tell me where, because I looked for it. I read everything that I had. Y'all, where was the paragraph? I didn't skip a paragraph. I didn't see anything else. I read everything that was there. Where is it? Tell me where to find it. I didn't skip it. I promise. I would never do that. Never. I'm nothing if not thorough to a fault, people, I would say. Okay, so right on which thing though? I pulled up like 6 different things. Okay, so while court is sensitive to the state's concerns, footnote 6. So in addition, the court understands and empathizes with the concerns that parents themselves, having done nothing wrong, would have and hold on, let me read that again. In addition, the court understands and empathizes with the concerns that parents themselves, having done nothing wrong, would have and the trauma they would endure because of a child being accused of and tried for capital homicide and their desire to be present for their child. Okay. So he's saying he understands how the family would want to be there. Further, the scope of his family member's testimony is likely going to be limited. In an effort to reach a solution that upholds the rights of both parties, the court will require the state to submit for an ex parte, in-camera review, a list of the Kohberger family members it intends to call at trial and the purpose for calling each of them. Okay. This is fair because here's the thing. It's holding the state's feet to the fire. Let me point this out. So remember how I was saying this looks like a tactic from the state to keep them out of the courtroom? This is fair because this is like making the state prove why they're going to call them, right? And then the judge can decide, like, you know what I mean? Like, look at this. This is actually a good idea. In an effort to reach a solution that upholds the rights of both parties, the court will require the state to submit for an ex parte, in camera. Okay, I don't like ex parte. I get in camera is appropriate review. A list of the Kohberger family members it intends to call at trial and the purpose for calling each of them. I would expect the defense to say something about the ex parte, guys. The state must also identify, but having said that, I don't like the ex parte, but I like that he's going to make the state articulate why they want to call each of them individually and what their reasons are. The state must also identify why each family member cannot be called very early in its case in chief, right? And there's that whole thing. And articulate why exclusion of a family member is necessary under Idaho rules of evidence, particularly given the unprecedented publicity of this case, which has made much of the evidence available to those who wish to know, including the proposed Kohberger family witnesses. So he's going to make the state bring the receipts on this, which is fair. Amethyst, which can you tell me which thing? I mean, yes, but I know. Happy Annie says defense isn't entitled to state's trial start. Yes, but ex parte is a really big deal. And I mean, the thing is this, right? Trial strategy is one thing, but they are entitled to know what, I mean, it's par for the course, right? To know generally what witnesses are going to testify to. And it varies by the state. In Florida, it's completely different, right? In Florida, everybody's deposed and everybody knows what everybody's going to say at trial, right? But I mean, they would be okay. If in fact the state is trying to keep the defense from knowing, okay, let's just in a hypothetical situation say that the state is going to call any of the family members, hypothetically. Then that would be, I think, some of that to our knowledge, right? So far the only lay witnesses where the defense would have literally no idea what they're going to be testifying about, right? You see why like, you know what I mean? Like, I feel like you can give the bases for calling them, right? The grounds as per the court's question, like, and why it can't be at the beginning of trial or whatever. And that wouldn't be giving away the full trial strategy. I mean, I would expect the defense to say something about the ex parte. I don't know if Judge Hippler will do anything about it. He might still say no way, but I feel like it's appropriate. I feel like it's appropriate for the defense to still be there. I don't think they need to get into their trial strategy. And I feel like it would be weird if like the family members are like literally the only lay witnesses where they don't have an idea as to what they're going to testify about. You know what I mean? So and I mean, and that's the thing, if they're going to interview them anyway, then why can't they be there? Right. So that's my point, right? Like, it just seems like it doesn't make any sense then. Now, remember, we heard in the hearing that they have not been interviewed by anybody, the family, apparently. So that's a whole other thing. But yeah, if they're going to, if everybody's going to interview, like, then anyway, okay. So the state must also identify why each family member cannot be called very early in its case in chief and articulate why exclusion of the family member is necessary under the rules. Right. Okay. We read this paragraph. Okay. The state must submit these materials no later than April 25th, 2025. The court, and by the way, I saw somebody ask if this was a new court filing. Yes, it would just came up yesterday, I think. I'll check on the date as soon as we're almost done. The state must submit these materials no later than April 25th, 2025. The court will provide the parties with its discretion at or before the pretrial conference on May 15th, 2025. For now, the motion is granted. As to the homicide victim's family and reserved as to the defendant's family. So in other words, he's reserving ruling. So this is interesting. This is, I think, the first time we've seen this from Judge Hippler, that he's reserving ruling because he needs more information. So this was filed on the 16th, but this just was posted. So I think, was that you, Tonka, that asked that question? Welcome, Doug. Just touched down. Were you flying for some purposes? Yeah, jurors cannot talk about the case until deliberation, with the exception of in Indiana, they can talk about the case before deliberation. That's the exception there. Everywhere else, not everywhere in the U.S., jurors cannot talk about the case with each other until deliberation. Oh, that's cool. See you both. Wait, you just touched down in Colorado. Don't you live in Colorado? Are you flying within the same state? Is that what's going on here? Okay, thank you, Amethyst. I would rather pull up the document though, because now it's annoying me if I missed it. So can you tell me which one it's in? Since we're done with this, we'll just go back through them again. So okay, so remember, so there is no other paragraph, right? Like there is no other paragraph. So there's that. Then we went to this one. We didn't do commercial burglary. I don't think that's applicable. Punishment wasn't the explosives, the burglarious instrument. Again, none of these have another paragraph. So I don't think that's what she's talking about. The thing that I downloaded, we read that entire page. The thing that downloaded a bazillion times, we read that entire page. Oh, you live in Chicago. Okay, hang on. I'm getting my wires crossed. Hold on. Okay. Yes, we have another scroll friend that has, I think, 4 words in their YouTube name that lives in Colorado. And so when I saw Colorado, okay, yes, now it makes sense. I remember that. I know you live in Chicago. Sorry, my wires got crossed there. Yes. Now that makes sense. It's just funny because the Colorado of it all. It's the jury instructions. Okay. Okay. Oh, you're talking about jury instructions just generally, not like specific to burglary? Hold on. Because this is standard. Like, okay, if any of the above has not been proven beyond a reasonable doubt. Yeah, that's reasonable doubt defined. That's standard. So I'm not sure what that has to do with the burglary, though. I guess I was looking for something specific to burglary. Have you not heard that before, official? Oh, okay. Hold on. Let me just fix this. I didn't read the last paragraph because I didn't think, okay. Hold on. All right. here's what it is. This is the paragraph that, here you go, Amethyst. This is the paragraph she was referencing. I didn't read this because to me, this is something that, okay, I maybe made an assumption that we all have this memorized. Sorry. I didn't read this because this is this in my mind, this goes without saying for every crime. This is standard languaging that I feel like is like, if I apologize if I incorrectly assumed that this is like everyone inserts this. I automatically insert this. So I didn't read it. And also because it wasn't specific to burglary. Like this is very generic. This is just literally on every charge, but I'll read it. If any of the above has not been proven beyond a reasonable doubt, you must find the defendant not guilty. If each of the above has been proven beyond a reasonable doubt, then you must find the defendant guilty. Literally in every jury instruction in every state for every crime. Very standard languaging. That's why I didn't read it. Okay, there we go. So again, the elements here, they have to prove that they have to prove the date, the state, the defendant, and again, we know they're going to say Bryan Kohberger, right? If the jury decides it wasn't him, then he's going to be acquitted, right? So that's what I'm saying. Like they're going to say the state's going to put the name Bryan Kohberger entered. It's going to say 1122 King, and at the time the entry was made, the defendant had the specific intent to commit murder. That's what this is going to say. That's what it's going to say. So they're going to have to prove that he went there with the intent to commit murder. Additionally, I will say, the jury could, let's talk about this. The jury could, it's possible, the jury could find him not guilty on the burglary and find him guilty of the murder. And what would that mean? That would have implications for the death penalty. The state would lose one of their aggravating factors. They would lose the actually the aggravating factor that applied to, I think, was the one that they dropped anyway, wasn't it? Right. It was I forget what it was called now, but they dropped that one. So no, I wouldn't actually have any implications, I don't think. However, the state probably would have intended to still argue, right? For an aggravating factor. I feel like it would have implications. I feel like it would affect things. Like I just wanted to point that out. It's possible. Like the burglary, like here's what I'm saying. Being found guilty of the burglary is not necessary to prove, it's not an element of the murder, right? So he could be found not guilty of the burglary and still found guilty of the murder, just hypothetically. Like it's not like he has to have burglary first. It's not a lesser included, right? So that's important to note. It's not a lesser included. It's not like they have to find that first and then murder. It's a separate indictment. So they could find him, and I mean, they could also, I guess, ostensibly find him not guilty of murder and guilty of burglary. But if that was the case, they would need another felony to insert besides murder, right? So I think the other way around would be more likely. But in other words, they're separate but equal. They could find both or neither or one or the other, right? Does that make sense? They can't prove that he entered the house. Well, that's going to be a fact for the jury, right? I mean, if they can't prove that he entered the house, then they can't prove the burglary is not the thing then. If the jury determines that he didn't enter the house, then he's acquitted of murder. Like never mind the burglary, right? The murder is the bigger issue. Burglary does not bring the death penalty with it, right? Right, it was dropped as an aggravator. Yeah, but the aggravator wasn't called burglary. It was like, hold on, let's just pull it up. I can't recall the exact languaging. Okay. Yep. At the time the murder was committed, the defendant, oh wait, sorry, committed another murder. There's hack, utter disregard. Okay, the murder was committed in perpetration of or attempted to perpetrate arson, rape, robbery, burglary, kidnapping, or mayhem. So no wonder I couldn't remember it. There's not just like a quick and easy name. Here, let me show you guys. I was thinking there was like a quick and easy name, sort of like hack or utter disregard, but there's not one. So it's right here. It's right here, letter G. The murder was committed in the perpetration of or attempted to perpetrate arson, rape, robbery, burglary, kidnapping, or mayhem. That's one of the aggravating factors that was dropped. They've got 4 left now. They've got the hack. They've got the utter disregard. They've got the multiple victims, and then they've got the what was the other one? Propensity, I think is what the other one is, maybe. Future dangerousness. Yeah, propensity. That's the other one. Yep. That's the 4 that they've got. They started out with like 7 or something. Initially they moved forward with 5 and then they dropped 1. Yeah, so I just named the 4. I just named the 4 that they're sticking with at this juncture. They've got 4. Hack, which is the heinous, atrocious, or cruel. Number 2 is the utter disregard. Number 3 is the multiple victims, and number 4 is the future dangerousness, also known as propensity. The reason they dropped this one with the burglary, I remember this. We covered it all. Well, of course we've covered it. It was because, and I pointed it out at the time, it was a lot of circular reasoning. It was like, basically it was redundant because there was an overlap here with like, oh, what was it? Like the future dangerousness, the propensity. Here's the future, right? There was a circular reasoning involved, and that's why it was dropped. The defendant by his conduct, here's the future dangerousness, but the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. Right, it is circular, yeah. And there's I can't remember. We went through all that. Like the states are when they were arguing about this, it was like really silly. That was a long ass time ago. I just don't remember specifically, but it was a lot of circular reasoning. And I pointed it out. I was like, this is insanity. And then the state dropped it. But they still charging the burglary for the indictment, right? For the guilt phase. So yes, does everyone understand the 4 aggravators? CYA. I don't remember what that is either. CYA. So cover. Thank you, Tonka. Cover your ass. Thank you. So I think we did it, guys. I think we did it. We found the paragraph with the burglary. We did the burglary. We did that hard. I think we did that hard. We recapped the aggravating factors. As far as the latest docs, this is the only one that has anything we can read apart from the DNA. Yeah, so like all these, you know, are just, I mean, I always open them just in case, but it's just like, there's nothing in it, right? It's just, yeah. For example, like this type of thing. Great. Okay, so that's really it for this live stream, guys. Multiple victims, heinous, atrocious, heinous, atrocious, and cruel is the hack aggravator. Multiple victims, utter disregard, and future dangerousness, also known as propensity. I'll put them in the chat. So oops. And then the 4. So the hack is the heinous, atrocious, or cruel. They're there. They're on the screen. They're in the chat. There you go, guys. If you want to write them down. Hack, utter disregard, multiple victims, and future dangerousness / propensity. Same. Okay, so I'm gonna make an executive decision. First things first, I'm the realist. I'm still in the murder business. I can hold you down like I'm giving lessons. Now I have it stuck in my head. Anywho, do you want a bad bitch like this? All right, we're gonna do this way. We're gonna have a surprise. We're gonna have a surprise portal. Whee! The best kind. Tell me why. Also, again, just for anyone who's now getting here, just to real quick say, for anyone who hasn't heard, on our next members only live stream will be trivia night again, and topics for this trivia night will be famous quotes, firsts in history, movie trivia, musical theater trivia, trial trivia, and 90s music. So study up for those of you guys who are competitive, if you feel so inclined. And like Sudi was asking, yeah, y'all can make bets. Bet away. Nothing in real life, you know, however you want to do it, that's fine. So save that. Okay. Perfect. So excellente. So what should happen is we should all be portaled into our next live stream. Surprise. Whee! Happy any like surprises? I think you'll like this surprise. Official, you old hag. That's how I remember hack. That is freaking hilarious. Love it. Excellent. Okay. Are you guys ready to be portaled over? I'm going to roll the outro. See y'all in a second. Love you guys.